Hey everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York, and in this video I'm going to talk about breach of contract in California. So the genesis, the reason I'm making this video is that I see a lot of people asking online. I get a lot of people asking me, I guess basically in real life, you know, Andy, I'm a party to a contract, but I need to break it because I lost my job, or, you know, I can't pay this or something. Or the other guy is breaking the contract because he decided that, you know, he couldn't afford to pay this or something. So, what do I need to do, or what needs to be done in a situation where a contract basically is being broken? So the kind of analysis for this actually is not terribly complicated. I mean, it depends a little bit on what the contract's about and, you know, how much money is involved, things like that. But the core concept a lot of times actually is fairly simple, and it's covered by the term mitigation and cover. Mitigation and cover. If I can figure out how to write it on the window over here, I'll put it over here. Mitigation and cover. So when I learned the term, I actually learned it as one term. So mitigation and cover is the term. I've run into some lawyers who basically learned it as separate terms. So mitigation or cover. The terms are used interchangeably. Regardless of how you learned it, mitigation and cover refers to the basic idea that a party to a contract who is not the one breaking the contract, they have an obligation to minimize their loss to a reasonable degree. They got to do something, they got to exert reasonable effort rather to minimize their loss from the breach of the contract, even though they were not the one breaching it. Right, so that's what mitigation and cover basically is. And to the degree that this non-breaching party cannot mitigate or reduce their loss, that amount that they cannot mitigate, that's the amount that the breaching party technically has to pay for, right? So hopefully that sort of makes sense. I don't believe mitigation and cover is kind of unique to California, but obviously I'm not going to go out and check every single state. If you're in a state not California, mitigation and cover, if it doesn't exist in your state, leave me a comment down below. As always, I'm interested in finding out how other states work. But mitigation and cover in California, at least, is a pretty fundamental concept in contract breach situations. If you need authority in California for mitigation and cover, the case that I always cite to is called AGAM, A-G-A-M. I don't remember the name of the other party, but AGAM is the case. I believe it's from 2015. The mitigation and cover concept is not, it predates 2015. The AGAM case is not the one that originated it, but it's the most prominent recent case, I guess, if that's the right way to put it, that discusses mitigation and cover. Yeah, so the AGAM case, I'll try to find a Google Scholar link and link it down below for you. So hopefully all of that makes sense. The basic idea behind mitigation and cover is that when you have a breach of contract, the non-breaching party generally has the obligation to try to mitigate or reduce or cover their loss somehow. And to the degree that they can't do that, because it's not always possible to do that perfectly, to the degree that the non-breaching party cannot cover their loss, mitigate their loss, whatever your term is, that's the difference, that amount that they can't mitigate, that's the amount that the breaching party technically has to pay for, right? So let me try to illustrate this with an example. For whatever reason, I always encounter this in kind of landlord-tenant types of cases. It's not unique to landlord-tenant, obviously, but landlord-tenant is kind of a pretty common example, I guess. So let me kind of explain it this way. Pretend, for instance, that you're the landlord and you have an apartment or house or building or something, and you sign a lease with a tenant to rent this, property to them for 1 calendar year, 12 months. And the rent, just to keep the math simple, the rent for that year is $1,000 per month. So $1,000 per month for 12 months. That's the basic lease. And let's say that your tenant moves in, pays rent for month number 1, month number 2, month number 3, etc. But let's say that after they pay rent for month number 5, they lose their job, or they get injured, or they have to move because their parent got sick and they have to go care for them or something. Something unexpected happens, which basically means that, or basically results in your tenant having to vacate the property early. So again, 5 months they paid for, they're supposed to pay for 12, but they need to move after month number 5, right? So from your perspective as the landlord, If the lease had been fulfilled completely, like if the tenant had stayed for the entire time, your money, the money that you would have gotten, is $12,000, right? So $1,000 per month for 12 months. That's what the lease should have given you if the tenant had not moved out early. But in this case, the tenant has to move out early for whatever reason, but they've paid you 5 months, $5,000. So your loss here is $7,000 because it's the rent for month 6, 7, 8, 9, 10, etc. Right? So in that case, do you as the landlord sue your tenant for that $7,000? You might, but unfortunately, you as the the non-breaching party, or fortunately, depending on your perspective, I guess, as a non-breaching party, you cannot do that automatically. Like you can't do that as your first resort, I guess. So what you as the non-breaching party have to do is you have to mitigate and cover your loss. So if you're a landlord and you have a place to rent, what that typically means is you have to go out and find a new tenant. Immediately, as soon as you know that this tenant of yours is going to move out early, you have to take reasonable action to go out and rent to a new tenant. You got to find a new tenant somehow. What does that involve? Maybe that involves putting ads on Craigslist, Facebook Marketplace, apartment.com or whatever. And, you have to go out and advertise, this place that you have for rent. And let's just say hypothetically, you do all that stuff. Depending on your area, the employment, situation in your area, the desirability, the time of the year, etc., you might be able to find a new tenant fairly quickly. Let's say it takes you 1 month to do that, right? So, your tenant basically pays rent for the 5 months. It takes you 1 month to find a new tenant. So your building, your property stays vacant for 1 month, but you do find a new tenant and they take over and pay the remaining 6 months of the 12. Right? So you've been able to mitigate your loss from $7,000 of a loss down to $1,000 because your new tenant is paying rent for those, for that extra $6,000. So the $7,000 that you lost, you've actually kind of mitigated or reduced that loss by $6,000 because your new tenant is paying you that rent. So for the actual loss that you're not able to mitigate, that $1,000, technically your old tenant has to pay that for you, like basically to make sure that you make out the same, you still get the $12,000 that you as the landlord should have gotten if the lease had basically gone to fruition. Depending on the situation, depending on the time involved, the tolerance, the patience of the landlord, some landlords will let that go. Other landlords won't, for example. I mean, it's kind of up to them. But the basic idea, though, in this example, is that the landlord, again, the non-breaching party to the lease, has a loss, because the tenant has moved out early. The landlord is basically short $7,000. Can they sue the tenant for that $7,000? Probably not, because they have to mitigate and cover first. In this situation, for the landlord, typically that means having to find a new tenant somehow, putting up ads, hiring a real estate agent, whatever. And if they are able to find a new tenant, that new tenant basically pays the rent in place of the old tenant in whatever amount of time, for instance, that it takes to find a new tenant, that the building or the property had to stay vacant. Technically, that's actually what the landlord would sue for. Right? So hopefully that all sort of makes sense. I don't mean to say, like I said, I think I said this earlier, mitigation and cover is not unique to landlord-tenant situations. It's not unique to California, as best as I know. But it is something where, I guess, hopefully you can kind of see the concept is fairly simple, but it is something that most people, I would say, don't really anticipate. Like when you sign a contract, most normal people don't anticipate, oh, what happens if this goes wrong? What should I do, etc. Lawyers, by their training, me for example, we're taught to kind of think, okay, what to do in the case that something does go wrong. But so I guess mitigation and cover is one thing that lawyers will tell you that you as the non-breaching party basically have to do when the other party to a contract breaks it for some reason. All right, so mitigation and cover, it's a pretty simple concept I'm hoping you guys can see, but it is something, if you are the non-breaching party, you have the obligation to do that. Again, that's the Agam case, which I will link down below. All right, so hopefully all that made sense, wasn't too confusing. Go ahead and watch this again if you want, leave me a comment, share, subscribe, all that stuff, and I will talk to you guys next time. Thanks.